Hello, and thank you for joining us for this video presentation on the pending numerous and important changes to the exempt market regime in Canada. My name is Aris Bloomberger, and I'm joined by my colleague Kim Poster.
Hello.
We have been asked by many of our clients to explain the importance of these changes and thought that this presentation could be used to help address some of the frequently asked questions we have been receiving lately. But before we discuss the substantive changes that are coming into effect on May 5th, let us tell you a little bit more about our firm.
Thanks. So AUM Law focuses on serving the asset management space. Our clients consist primarily of investment fund managers, portfolio managers, dealers, as well as private and public issuers and investors. So in any one typical day, our lawyers are doing a variety of activities. We could be registering an individual or a firm in one of the registration categories. We could be helping a public issuer out with its disclosure issues, forming a fund, and just answering general compliance and fund formation inquiries.
And to best serve our clients, we have offices in Toronto and Montreal with 3 practice groups divided among regulatory compliance, investment funds, and corporate finance. And if you want to learn more about us and our people, please check out our website at aumlaw.com. And yes, the AUM in our title does stand for Assets Under Management. So now, Kim, turning to you, why is May 5th an important date?
Well, as demonstrated by the title of our presentation, Aris, May 5th is the date that a number of really important changes are happening to National Instrument 45106. And as many of us know, the rule is important for virtually all fund managers, portfolio advisors, and dealers, because what the rule does is it sets out the primary exemptions from the prospectus requirements right across Canada. And without a prospectus exemption, you need a prospectus to distribute securities, including investment fund securities or securities of any other private corporate issuer. So what these changes do is they impact 2 of the most commonly used prospectus exemptions used to sell securities, the accredited investor exemption and the minimum amount exemption. So currently, an issuer is permitted to distribute securities to an accredited investor if certain conditions are met. And there's a very complicated definition of various categories of what it means to be an accredited investor. Now, the minimum amount exemption is an alternative exemption that you can use that permits someone to distribute securities to a purchaser provided that they buy at least $150,000 Canadian worth of securities, again, subject to various conditions.
Now, we know that over the past few years, there's been a lot of talk about increasing the income and asset thresholds and the definition of accredited investor. To be clear for our viewing audience, the latest round of amendments to 45106 do not have this effect. That's correct?
Right, that's right. So there's no changes to the income and asset threshold. An accredited investor still includes, the 3 most common categories of individuals. So those are an individual whose net income before taxes exceeds $200,000, $300,000 with a spouse, or an individual who owns net financial assets of at least $1 million, or an individual who owns net assets of at least $5 million. So those thresholds haven't changed, but the definition has in fact expanded in a number of important ways. So it now includes, for the very first time in Ontario, a fully managed account purchasing itself as an accredited investor. It can now purchase investment fund securities. So for example, if you are a portfolio advisor with discretionary authority over your client's accounts, you can now purchase the securities of a fund as an accredited investor. And what this does is harmonizes the exemption across Canada.
So this is a much long-awaited amendment to 45106 for Ontario.
Yeah.
But let's stay with that exemption for a moment. We know that the expansion of the exemption to remove the Ontario carve-out in order to permit non-accredited investors to be able to purchase an investment fund product. We know that this change is going to come potentially raise suitability concerns because we're going to have people that otherwise would not have been purchasing this product, purchasing investment fund product for the first time. Do you see these suitability issues as being important?
Yeah, that's a really good point. Suitability is obviously a critical and distinct step that always has to be looked at carefully and documented fully. Something our portfolio advisor clients are well aware of. If you have discretionary authority, you have a fiduciary duty to your client to act in their best interests. So the suitability is something that might in fact be worthy of a separate presentation because there's so much to talk about. So now it's my turn to ask you a couple of questions, if you don't mind. We've mentioned some of the changes that have happened in the definition of an accredited investor, but there's been others as well.
Yes, and this presentation isn't going to cover all of the changes, but the one change that we did want to discuss with you as part of this presentation is the expansion of the definition of accredited investor to include family trusts that are set up by an accredited investor. Now, there are two conditions to this new provision in the exemption. The first condition is that the majority of the trustees have to be accredited investors, and the second condition is that all of the beneficiaries of the family trust must be specified family members as defined in the provision.
Okay, so that all sounds good. The expansion is good. But I've had a number of clients call me and say that they've heard, whether it's in the media or just through word of mouth, that the new rules actually make it more difficult to sell securities. Is that true?
Well, I think the reason people are talking about it being more difficult to sell securities is that the definition of accredited investor now requires that the individuals that you were speaking about a few minutes ago, the $200,000 income earners and the 1 million financial assets and 5 million financial asset people, that those individuals must receive a risk acknowledgement form.
Okay.
So that's changed, and that's going to require a different discussion between the dealer or issuer and the investor. And the second change, which may restrict the distribution channel for product, is that the minimum amount exemption will no longer be available to individuals. It will only be available to corporations. So people are taking note of that change and worrying about whether it will restrict capital raising. One important caveat with that change is that corporations that are utilized for tax purposes or pre-existed the amendment to the May 5th amendments may still be available. It's just the one word of caution is that people be careful with setting up corporations solely for the purpose of relying on the new version of the exemption and receive advice in that regard.
You definitely want to be careful about using that exemption now that it's changed. And something else I think that's important to note about the risk acknowledgement form that you just spoke about is that the form isn't as onerous as it otherwise might have been. The first version that came out almost a year ago would have required the dealers to sign the form as well, which would have been another added extra step for clients. So that's good news that didn't come into force.
Absolutely. Now, Kim, let me ask you, aside from the changes to the accredited investor and minimum amount exemption that we've discussed, are there any other exemptions coming into effect in Ontario that you think are worthy of discuss?
Yeah, absolutely. So also on May 5th, there will be a new friends and family exemption that's available to specified friends, in quotation marks, and family members. And that will not be available to investment funds, but it is available for other issuers. And everyone will want to stay tuned for separate initiatives that are coming down the pipe in Ontario, specifically the offering memorandum exemption, and everyone's favorite exemption, the crowdfunding exemption.
Yes, I know that people are eagerly awaiting what the Ontario Securities Commission is going to do in terms of its new proposed OM exemption.
Yes.
And in terms of crowdfunding, let me plug our recently released equity crowdfunding bulletin that's available on our website. Okay, so Kim, now that we've talked about these pending changes to the exempt market regime, let's talk in a little bit more detail about what dealers and advisors and others need to do in order to get ready for May 5th.
Yeah, absolutely. There's a lot to do actually to get ready. Most of our clients will have subscription agreements and offering documents, whether that's an offering memorandum or a term sheet, and those will all be very specific. They'll specifically refer, for example, to the definition of an accredited investor. So all of that will have to be very carefully reviewed and vetted and revised. There's potentially other documents as well. For example, if you're registering your compliance manual, might have specific references that have to be updated. For funds, they're constating documents, so they're limited partnership agreements or their declarations of trust or trust agreements might specifically reference certain exemptions. And even potentially for advisors, their IMAs might have to be reviewed.
Right. So for those in the audience viewing this presentation, you should know that we've been able to help a number of our clients to date with questions and with the documentation related to these important changes. And of course, we'd be pleased to assist you with this work as well. In many cases, we'll be able to do so on a fixed fee basis. So ask us about that when you call us. And also consider this round of amendments as a good opportunity to update your offering documents for other changes that have occurred, not only regulatory changes, but changes in the business and affairs of a particular fund in order to ensure that there are no misrepresentations in these documents. And it's also never a bad time to think about conducting a compliance assessment. So in any of those respects, please contact one of us, and any one of us or 20 in Toronto and Montreal would be very pleased to help you.
So thank you very much for watching and have a great day.
Thank you.